Hello, everyone. My name is Susan Hoffman. I'm the director of the Osher Lifelong Learning Institute here at UC Berkeley, and we're delighted to welcome you to today's speaker series. The series brings leading voices from campus and other experts to talk about current issues, scientific breakthroughs, and new thinking in a variety of fields. We are fortunate this term to have a variety of emeriti and faculty from Berkeley School of Journalism. And so I wanted to simply mention that OLLI members have the opportunity to hear from Cynthia Gorney this week in Bill Sokol's course on the Supreme Court. She'll be a guest speaker to talk about the Roe v. Wade decision and now the impact of the Dobbs decision. And on Wednesday, Adam Hochschild will be at Freight and Salvage talking about American Midnight, his most recent book. And as he has done in previous OLLI courses, he talks about the history, the methods of the investigative reporting that went into recounting a very important time in American history. We also will have sociologist Arlie Hochschild will talk about her latest book, Stolen Pride, Loss, Shame, and the Rise of the Right. And she will be in conversation with another journalism professor, Deirdre English. To keep in the vein of politics, I want also to mention a 4-week course that will begin on October 16th. Politics professor Darren Zook will have a course that is entitled National Election Beyond the Headlines. There'll be 3 weeks before the election and then 1 day after the election, the class will meet. We will also have a town hall meeting at the end of the week when we have the national election. Today's speaker is Lowell Bergman. He's legendary as an investigative reporter, as well as emeriti colleague at Berkeley School of Journalism. We've invited author, educator, and OLLI faculty member Peter Richardson to introduce Lowell, the topic, and to help moderate the conversation. As usual, you know that those who are registered for today's event, you will receive a copy of the video once it's been captioned and posted to YouTube. And for today, what we ask is if you please post your comments or questions in the chat room. We will see how much time is filled with the conversation between Lowell and Peter. And if we cannot address all of your questions, Lowell Bergman has offered to review them, and we will see how we can best respond if we run out of time. So with all of those, let me now say, Peter Richardson, the floor is yours.
Thank you, Susan. Yes, excuse me, I'm Peter Richardson, and it's my honor today to introduce Lowell Bergman and quiz him about his topic. The First Amendment is not a suicide pact. As many of you know, Lowell held a distinguished chair in investigative journalism at Cal and co-founded the Center for Investigative Reporting here in the Bay Area in 1977. And CIR merged earlier this year with Mother Jones. Lowell worked in national television news for many years with ABC's Dateline, with CBS's 60 Minutes, and PBS's Frontline. His 60 Minutes investigation of the tobacco industry was the basis for The Insider, which starred Al Pacino as Lowell and received an Academy Award nomination for Best Picture in 1999. Lowell was also a New York Times correspondent until 2008 and a senior producer and consultant at Frontline until 2015. His work has received many prestigious awards, including multiple Emmys, duPonts, Peabodys, plus a Pulitzer Prize for public service in 2004. Lowell's interest in today's topic goes back at least to 2007, when he produced a 3-part documentary for Frontline on the news industry and its challenges. As for my background, I taught courses on American Studies at San Francisco State University, and I've written extensively about American journalism and journalists. including books and articles about Hunter Thompson, Ramparts Magazine, and Carrie McWilliams, the radical author and editor of The Nation magazine. I'm now writing a book about the first decade of Rolling Stone magazine, which it turns out was also one of Lowell's employers in the 1970s. So it's not very often that an accomplished investigative reporter even considers the possibility that the First Amendment might be a suicide pact. So let's get right to it. Lowell, what's the main problem with our current approach to electronic communication on one hand and free speech on the other?
Well, first of all, free speech has never meant in the past that you have a right to infinite reach. And that particularly became, as I found out, actually, because of what was going on around all of us, the rise of Donald Trump and the rise of news that you couldn't decide whether it's true or not. It became clear to me that we don't ever refer to the past and the history to look for lessons about what's happening today. And so what I realized in that effort that started basically at the pandemic level at a time when I discovered that the library at Berkeley still had researchers you could reach, and I got some help, that the deregulated electronic media situation that we're in today is unique, that it didn't exist, as I knew from my own personal practice before 1988. It was regulated. Content was regulated. Things did happen. The Supreme Court did uphold actions related to broadcasting stations that were, if you will, as much as lifting their licenses for the content that they put on the air. Now, that's a longer discussion, but by the way, it's a subject that's not even presented at journalism schools across the country about that history, and it's been totally forgotten. So going back to that, I worked my way forward and into the issue of how we have a doctrine of free speech, which even Erwin Chermaninsky, who is a great advocate, the dean of the Berkeley Law School for unfettered free speech, is now questioning. And a situation where unless we do something, unless we find another way of regulating what's going on, we are, and especially with the protections of the currently of the First Amendment, we are doomed to follow, and there doesn't seem to me to be a peaceful way to get out of this.
Okay. Well, as you point out, the timeline for this issue stretches back quite a ways, almost a century, actually. But a few dates stick out. I wonder if it's worth ticking off some of the big landmark events and decisions. The first arrives in 1934 with the passage of the Communications Act. So why was that law so important? And where did its language come from?
Okay, well, so being like sort of anybody else who I think in the business, we understand that the FCC Act of 1934, it has a clause in it about the public interest. It also says no censorship. And that public interest clause was in effect until 1987, when Ronald Reagan repealed almost all the relevant regulations. And by the way, so those regulations had to do with how many stations you could own. People don't remember that a network could only own three stations. Not all regulations were repealed. For instance, you have to be a U.S. citizen to own and operate a station. That's why Rupert Murdoch became a U.S. citizen. However, things like the Fairness Doctrine, which gave you the right of reply, the audience had rights, et cetera, and that some things like news were required by the FCC. Look at the current landscape. Look at the great distributors today of information. 1934 would have made impossible, with the regulations that were then in effect up until 1987, would have made impossible the activity of Donald Trump on the air. It wouldn't have happened. He wouldn't have been there. Now, the past in that's another little thing that I discovered. I always thought the law came out of the New Deal, but if you want more, Peter, about it, it actually came from Herbert Hoover.
That's amazing. And where did that language originate?
Well, it's very similar to the story of the internet, except a different outcome. A new fantastic technology, innovation was released from the military, just like the internet, to the civilian population in the 1920s. And immediately everyone flocked to use this. They built transmitters, anything goes. Freedom was the calling card for it. And the result was chaos. And in the next 2 to 3 years, given a law passed in 1912, the question of what would happen with this in the private sector fell to the Secretary of Commerce under Calvin Coolidge, who was Herbert Hoover. And Hoover's papers reveal that he engaged in a nationwide survey, basically, of what people wanted to see happen. The result was the Radio Act of 1927, which had in it for the first time the phrase public interest and convenience. That's the standard for the station to work under. And provided for, if you will, action by that the public might dislike something, they could complain to the radio commission that was created, and in turn, action could be taken. And I suppose the most striking thing about it, if you think about, for instance, former President Trump talking about hydrochloroquine, I had to write it down to remember when he was recommending that for COVID. That would have been impossible. This station would have lost its license if such a thing had been on the air and someone was saying it, and the stations wouldn't run it, or they'd bleep it out, or there would be some form of interference at that point. Back in the old days, back then, there was a Dr. John Richard Brinkley who had a station in San Antonio that was urging men who were worried about their potency to have an operation which would supplement their own testes with goat glands. This became a national phenomenon, and his license was removed. You don't see that today because it can't be done anymore, and it's because of the interpretation of the First Amendment.
And the public interest standard, presumably.
Right, and the public interest standard that's in that law, right? And it's still there today.
Yeah, okay.
Hasn't ever been repealed.
You mentioned the fairness doctrine. I think that might have been formulated in 1949, or it was established then. What was that? I mean, you mentioned it a little bit, but what did it mean for electronic communication?
Well, first of all, it's important to understand that there were already regulations and licenses being pulled related to hate speech and misinformation, et cetera, and upheld by the federal appellate courts up to, let's say, 1949. The fairness doctrine required that the stations give equal time to all kinds of any opinion or party during an election. It also provided for rights of the audience, which sounds like a really unusual thing because we have no rights right now in terms of the internet. Rights of the audience, and one of them was you couldn't personally attack anyone without giving them equal time to reply. And that part of it was upheld by the Supreme Court in 1969. And that became something which the stations, as they were managed in general, they were afraid to do things that would force them to do, if you will, some kind of ameliorative behavior like equal time. They'd lose time for advertising, and it would become an economic question for them. So they were careful to stay within the boundaries of the regulations as they existed.
And so this whole notion of public interest wasn't an abstraction. It was something that was shaped both by the laws and by court decisions. Even if you couldn't provide a bulletproof definition, it was getting hashed out through different mechanisms that were well established.
I mean, it would depend upon what administration was in power, to what extent these things would be enforced with the broadcasters. But the best example, the historical example, is Newton Minow, who was the head of the FCC under John Kennedy, who famously spent a week watching everything on television. By the way, there were no replays, so he had to do it in real time in 1960, I think it was 61. And he goes to the National Association of Broadcasters to give his inaugural speech, and he describes what he saw as a vast wasteland. And he gives a whole long list: murder, gunfights, et cetera, et cetera. And even though it was much tamer than today, and it scared the bejesus out of the broadcasters. So all of a sudden, in the next couple of years, you see national news go from 15 minutes to 30 minutes. You see documentaries back on the air, et cetera, breaking into regular programming to show the Fulbright hearings. So it had an effect. Whatever the head of the FCC said, people shivered at the other end if it looked like they'd have to do something and it endangered their license. And maybe a closing thing about it, Herbert Hoover was responsible for making the annual fee for your license affordable to anyone in your community. It was $100 a year back in the 1920s, and it's still the lowest cost and most profitable license issued by the federal government.
So it wasn't as if people were being crowded out by financial concerns when it came to obtaining a license.
Well, there was again, it depended on the administration that was there, but the rules were there, the laws were there, and the behavior, going back and talking, for instance, with attorneys who represented stations in those days commercially and so on, and their concerns, they would get prepared for a review from the FCC every year as to their behavior.
Right, right. This might be a good time. I mean, with the rise of television and more people getting their news from television, this might be a good time to distinguish that medium and radio from print journalism and the standards that apply to print journalism. What are some of the important differences between them?
I think important understanding here is that, yes, there was freedom of speech in the 1920s. That was in the Constitution and the First Amendment. But there was nothing that said you had a right to infinite reach. And that's the key difference, I think, with the introduction of electronic media. There's no filter. There's an infinite audience. And there's rarely the possibility of making much of a difference. Because and I remember people in great tension before there was a replay at ABC News, when the World News was put together back in the late 1970s, because you can't make a mistake. If you make a mistake, it's hard to run. You don't have the time the next day to run corrections and so on. So there was a tremendous focus on not, if you will, presenting the public with information that was untrue or could be challenged. That tradition at that point was over 50 years old, and it comes with the beginnings of radio and broadcasting. Look today at the streaming platform you use. See what they say is a documentary, if you know something about the subject. See if there was fact checking. You don't know. They don't know. They don't say. Except for libel, you assume that they are not reviewing for that purpose. And so we don't have the same standards in place. We don't force people into those standards at work. Anything goes today. And that's why nobody knows what to believe.
Yeah. Now, it's around this time that you break into journalism, first in print journalism in San Diego, but very quickly, and also in the Bay Area. But you also start to do television in the 1970s, I think it is.
Yeah, 78.
Mm-hmm. So you're aware of the differences between, the regulatory scheme in print and the regulatory scheme in electronic communication. But when you came into television, what kinds of exposure did you have to the standards and practices that were expected of you? What kind of training or what kind of awareness did you have as a correspondent?
In January of 1977, ABC News offered me a job trying to create their first magazine program, which became 2020 in that spring. And they said I could stay in Berkeley. So that was actually the big selling point for me. And so they shipped me a copy of the binder, the standards and practices of ABC News. And I had to sign a document saying I read them. And it was mostly either legal decisions, FCC regulations, ways in which you had to behave, people's expectation of privacy, which had been adjudicated in terms of like moving a camera, whether it was a film camera or a video camera in those days, let's say into a restaurant, just to follow somebody in. You needed permission. There were all kinds of regulations in place about and practices and standards that the network put in that caused you to tell people what was going on, how you were going to operate, etc. So all of that kind of stuff was new to me. That there were ways you could behave, the ways that you did things. Yes, you could talk to the editor at the newspaper and ask him, could you do this or could you do that if you were worried? But you were very rarely concerned until after you wrote the story what the consequences might be, and then you'd have to meet with a lawyer, etc. With the news, it was very different, and there were what we would call limits on what you could say and do that had been established for, at that point, 50 years.
You spent a little bit of time, based on your print work, in some legal cases that were brought against you and your co-author. I mean, could those have been would those have been in any way different if those stories had been delivered electronically? I don't even know if you want to talk about this, but if you do,
I mean, well, it would have been much more difficult in certain ways to do some of those stories in electronically than in print. Again, because in those days, especially, there was much more difficulty in nuancing the story and how much time you had in terms of an investigative story. I would say that I learned a lot from the litigation. It's kind of like I became the Lenny Bruce of libel, if you will, for a while. But it did result in some pretty good Supreme Court decisions, particularly about investigating wrongful imprisonment and conduct of law enforcement in particular, but also about organized crime and related issues. But the libel standard has nothing to do really with the overall presentation of the news. Okay, in print there was no restrictions as to how you laid it out, how you presented it, and so on and so on. From the very origins of radio, there was a public understanding, a government presence that took care of the problem that later emerged in 1934 and was voiced by nobody less than Joseph Goebbels, who said that the Nazis couldn't do it without radio. And the Nazis had a hard time getting in print. Newspapers would make fun of them. They were cartoonists, etc., for Adolf Hitler, but they could get on the radio, and that's how they communicated with the masses. And they had infinite reach. And I would present today that I don't have any problems having total free speech as long as you have some control over the reach.
Yeah, interesting. I mean, that's changed. The technology's changed a lot, even since your earlier days. But I just wonder, at that point, early on in your career, did those standards and practices or those regulations in any way make you feel like it impeded your ability to do your job?
I think what they did was they helped me do my job. Look, the networks were profit-making organizations. They were interested in the bottom line. It was only because there were regulations in place for their licenses that they themselves had developed their own standards and practices, which they imposed on the people who worked there. And you, in turn, could go to your management people. They even made me an executive at one point. I know I was surprised. But to make arguments for stories that involve some level of risk. And that's what you're talking about often when you're trying to develop new information. You're not just rehashing the news, but you're putting news into, let's say, 2020 was supposed to be a news magazine. The same thing is true with 60 Minutes. There's plenty of profiles of celebrities on 60 Minutes, but what it got known for was doing the kind of stories that made a difference to the public and broke news and operated like a regular news organization. And that's what's key. Then look today, no regulation today. Show me a streaming service that's invested in news and breaking news. I'm looking for one right now, actually.
And that's something, I mean, just in general, quite aside from the larger picture of the regulatory scheme, is that the economics of news are such that it's always cheaper to do opinion and analysis. Let somebody else gather the news and then just put up put up your, circulate your opinions, dance on top of the news gathering that other outlets have done. What you're saying is that, even in a profit maximizing scheme, you were able to do the kind of work that you wanted to do, even with the regulations on that activity.
There would have been no reason to hire me and pay for my expenses if you weren't interested in that. When I went to broadcasting, I remember Cy Hirsch, who was a famous investigative reporter at that time, as he is today, called me up and said, "Hey, you're not going to get real bylines. Somebody else is going to get credit on the air for the story. They're not going to let you do this or that, right? You're just going to be putting pictures in the print stories. That's what you guys do in broadcasting." And that was the sort of division between, if you will, between people who got into broadcasting versus print. I can remember going to the New York Times in about, 1999, and people were looking at me askance because I came from broadcasting. So there was still a cultural resistance, but there was no question by then that investigative reporting could be done in broadcasting as well. And despite the fact that print people didn't think so. And obviously the big difference for me was I had a bigger audience, and I could reach that audience by doing stories. I did a local story, a wrongful conviction story that resulted in the 9th pardon of innocence that was done about a guy named Pete Pianesi, and influenced, according Gavin Newsom's father was a defense attorney in the case, and he brought it up in his own discussion of suspending the death penalty. So that was a broadcasting piece in the Bay Area that had never appeared in the Bay Area and wouldn't have without letting me loose to fulfill the public interest standard for ABC.
Right. It's important maybe to note too that at this point you worked for 60 Minutes for many years, and 60 Minutes figured out how to make money in the news division by bundling investigative reporting of the sort that you did with some lighter fare. But you pointed out in an earlier conversation that show only came on when it did for a very specific reason. Came on Sundays at 7:00. Why is that?
Well, because 60 Minutes was a failure when it started in 1968 until 1973. People didn't watch it during regular broadcast hours, and they kept moving it around into different slots. And as they themselves, Don Hewitt himself, said, the FCC created a special time period on Sunday evenings where the network had to have at least 1 hour of public interest broadcasting, something other than a sitcom or something just developed for commercial purposes, children's programming, something within that boundary as it had been defined. And they found in 1973, when they moved it to 7:00 on Sunday, their ratings went sky high. And within 2 years, they were in the top 10. And they stayed there longer than any other program in the history of broadcasting coming to today. But that regulation, nobody at 60 Minutes today that I called understands that there was this regulation. It lasted for 20 years, and by then 60 Minutes was, well, it's because regulations ended. I mean, that's what happened. So it's with the help of the government that the distribution of news took place on broadcasting, period. And second, that broadcasting that became in-depth to any extent to meet a mass audience.
Right. You mentioned earlier that the whole regulatory scheme for electronic communication, especially television, changed radically in 1987 when the Fairness Doctrine was repealed. Why did the Reagan administration press for that? And what was the practical effect of that repeal?
Well, there are various reasons why. Ronald Reagan was upfront during his campaign. He said the government is the enemy, and he went forward in that way. In the inner circle at ABC News, which they let me into, there were in 1981. there were open discussions about we're going to get rid of all these regulations with the administration. All the networks were trying to get rid of it. Why? Because they could make more money. I mean, for example, you couldn't sell a station just to anybody. There were all kinds of regulations that started in the 1920s about who could own a station and why it was important to the national security. You couldn't, for example, have a station that was owned by a company that also was doing business with the US government. The defense industry couldn't own anything. Major corporations like General Electric, and the list goes on, could not own stations. Reagan initially got rid of all the ownership restrictions. So that's when you started seeing the selling of the networks. And of course, the stock price went up. And everybody talked about that in the meetings, that we're going to make more money. We got special stock options, et cetera, because you're now an executive. So there was a financial interest in doing that on the industry side. And then from Reagan's point of view, this was a way to open up content to just about anyone. So when you see the regulations pulled from the Fairness Doctrine in the end of 1987, the next year you see Rush Limbaugh. And ironically, or sadly, the next year you see the introduction of the internet from the military to the private sector into a world that's not regulated and never would be. And you know, an old FBI file says I'm an anarchist, you know, and what it led to was anarchy on the internet, right? In the end, and I know how many arguments that I was unpopular with people, because I was teaching part-time at Berkeley at that time, with a number of people about talking about you need regulation in the internet. You need some rules of behavior, rules of the road, guidelines. Because if you don't have it and you're going to try to make money on it, all hell will break loose. Well, you look at the First Amendment decision, which is, you know, Reno versus the ACLU and Section 230 and the ability of profit-making organizations to distribute material to a vast population and not have to have any responsibility for the content. That's what's going on still today. And obviously, people are talking about reforming it, but you can't get anything through Congress. And that's partially also due to a First Amendment decision called Citizens United, which gave money on unlimited First Amendment rights. But I don't want to get too much in here at once. But the key question is, who should be trusted with infinite reach?
Right, right. You know, you mentioned the public use of the widespread public use of the internet. Another thing that came along during that time, and you mentioned Rush Limbaugh, another thing that came along during the time was the establishment of the Fox network and Fox News. Would that have been possible, the kind of journalism that they were doing under the old regulatory scheme?
Well, they would have to be accountable for saying things that they're balanced, you know, claims that they were making in terms of promoting themselves, the way in which they presented a partisan view of the news, basically, which I don't think they deny that. They have some partisan role in what's happened today. But it goes beyond Fox. It's all kinds of things that are possible. Alex Jones would not have been possible. There was a very groundbreaking court decision in 1931 related to the Radio Commission that had been set up through Hoover and Congress, in which there was a doctor, I think it's John Brinkley, in San Antonio, Texas, who had a station, and he was selling operations to put goat gland testes in yours if you were male, and improving your sexual activity. This went nationwide. And
there were other cases too that had more to do with hate speech, and radio stations had their licenses pulled.
Right, and there's the Schuler case in Los Angeles where a preacher was preaching the doctrine of the Ku Klux Klan. He got his license pulled, as did Dr. Brinkley, and that all went to the Federal Court of Appeals and was upheld.
Right. So here we are now in 2024. News organizations, I'm thinking especially of newspapers, have been shedding jobs for decades. There doesn't seem the business model is broken in part because the advertising has been that they depended on has been diverted to tech giants like Google and Meta. We've endured this explosion of misinformation and disinformation, especially online. So how do we start thinking about, even if we agree on the problem and its sources, how do we start thinking about solutions?
Well, I think we have to look. There's some interesting things going on in Washington right now, but before I go back to those, what happened with me doing this, looking into all of this in recent years, is that all of a sudden I stumbled over and had no idea that was going on, that the European Union had sent a special envoy to Silicon Valley to inform them that they were about to become a regulated industry. This was almost 3 years ago. And because of that, I started to look into what was going on in Europe and then globally. This is now a global problem because the internet has global reach and does affect many other countries, obviously. So right now, the European Union has in place, for instance, regulations related to content, regulations related to targeting advertising to children, regulations related to monopolies, and a regulation and a law covering AI, artificial intelligence. So they're way ahead of us in many ways in taking a clear look at what's going on in the world of the internet. We'll have to see how that unfolds in the next year or two, because they're starting to enforce those laws, or have been over the last year. But that's led and apparently has encouraged, for instance, what's happening in Sacramento, an attempt to deal with it by the Newsom administration and the legislature. And there's beginnings of activity, as you may have noticed, in the Justice Department and the Federal Trade Commission looking at the internet. So there's activity in this area for the first time over the last couple of years.
In Europe especially, would any of our First Amendment law affect the kinds of regulations that are being established there, or are the situations sufficiently comparable to sort of see what best practices there might be and how they might play out here?
Well, we can't ignore the fact that the Silicon Valley now has 7 of the 10 richest corporations in the world, and they lobby around the world, or they are attempting, and some of the companies are attempting to make nice with journalism and try to soften the edges, but that's a huge question. It's a huge question that's we'll have to see in this election, no matter who gets elected, whether what little action is going on in Washington continues. And then there's the whole question of Congress ever doing anything about it, and they're totally gridlocked at this point. So this is a major political question, which I really don't have that much insight into, other than I can tell you that some people in Washington that I've talked to are, for example, very encouraged by the activity in the Department of Justice, for instance, and the issue of monopoly. But it still doesn't get to content. And the content issue, I think, is critical because, just think of it. I mean, there was a Dr. Brinkley, right? And he got his license lifted. But we had a president of the United States urging people in the era of COVID to take a drug that nobody had any idea what it would do to you, much less aid you with COVID and help you with COVID. And there were no consequences.
Right. We also had a news organization that ran a story that they knew to be false over and over and over again, and did get taken to court. But there was no, as far as I know, of course, there was a big settlement, and a fine probably, but no, there was never any talk about anybody's license being pulled.
There is no license. Fundamentally, there is no recourse in the licensing procedure that's realistic at this point. And there's no licensing, obviously, on the internet, right? So anything goes.
Right. Okay, let's say, forget about the tricky political problems and power politics. If you had a magic wand, how would you use it on this question?
Well, I would have, I would have, in a way, the same reaction. I find it odd. Herbert Hoover wasn't my hero. At least my grandmother was not happy with him. But if you read his papers and see what was going on, there was an open discussion going on about what do we do about this? What are the standards? What should happen?
For radio specifically at that
Radio
time.
is a
Yeah.
new technology that had
Right.
infinite reach.
Right.
Right, and plenty of promise, and all the same kind of utopian talk about everything will be solved, or all these problems would be solved in some way by having radio. You could have a instantaneous emergency declaration going out, and let's say if there was a hurricane for the first time when you had radio, just as an example. But right now, the internet isn't required, or an operator using the internet isn't required to do very much in the public interest. Now that they've solved the problem of how to do commerce, which was a problem for them in the first 15 years, now that Google solved it first and then others afterwards, and now that has created this phenomenal wealth that has allowed these corporations to become as powerful as they are and as ubiquitous as they are, it's a time, it seems to me, where we got to rethink how this is all going. Otherwise, we're going to create more of the same, which is a continuing division. And here I get very pessimistic about, Erwin Chemerinsky is talking about a new constitution. You're not going to have that unless you have a civil war, because the issues now are ingrained in a way that's unlikely to change very quickly.
Is a broader conversation about the public interest kind of resurrecting that notion? And is that, do you see any upshot or any benefit from that, or even whether or not it could happen?
Well, there are a couple of books out there, a couple of professors in different places at Duke and University of Pennsylvania who have joined in with people at the University of Illinois who were pushing this years ago to take a look at the public interest standard and try to use that history in order to build a new reality. But we're still in the infancy of that here. I think you keep an eye on the impact of Brussels, of the European Union, because they're about to start regulating, and there's definitely going to be some kind of confrontation over that, because Silicon Valley is also showing resistance in a number
Got
of
it. Just FYI for the people joining us, that are those professors, are you thinking of Victor Pickard and Robert McChesney and folks like that?
Yeah.
Or
McChesney's retired, but there's forgot his first name, Napoli and Duke University. There's various people writing about it. The question, it seems to me, is whether or not we can re-educate the legal profession in the United States, which seems on both sides of the spectrum to say that you can't do this under the First Amendment. You can't moderate content, basically, unless you're the company itself that owns it. So we've given the issue of infinite reach to private industry with very little in the way of oversight. And so it shouldn't be surprising. If we had done that in television when I was there, I would have never gotten a job.
how come?
Huh?
Why wouldn't you have gotten a job?
Because it's more expensive to do real reporting. And rather than make it up, which is literally happening today, making it up, right?
We're letting the robot make it up.
Or now, yeah, the AI making it up, even save you some more money. And because we're at a level right now of, it's a combination, I think, of things. Public education itself has always needed more support than it's gotten. But now it's falling apart. And no one teaches, or very few schools teach, for example, media literacy, so people could understand what was going on before the internet, much less now.
Right.
Right. So we're in a very difficult situation. I'm not sure that I don't even have a recommendation about which way to go. That's possible.
Yeah.
A First Amendment that says you can, that money has First Amendment rights and there's no limit. I mean, what was Watergate all about? So the lessons that have been discarded and in some ways actually even overwhelmed many in the legal profession. So now that it's anything goes.
Yeah, yeah.
I mean, what can you have if that's the absolute right that people and companies have?
Right, right. Well, I have a lot more questions, but I think we've covered the waterfront for now, and I know we have some questions online that people might want to put to you, Lowell. I'm going to leave that to Susan and Max. I've seen some pop up in the chat room, but I don't have that up right now. Are there questions from the people joining us?
There certainly are. And they're very long and rhetorical, and I'm trying to see if I might be able to encapsulate a few of them. I mean, they are very interested to know more about what are the standards and how do you define the public interest? And so whether or not, Lowell, that sends us back to the Hoover documents or to the EU to look what Brussels is going to be doing or what the Newsom administration is doing, would it be possible, in the interest of answering a few of these questions, do you have particular examples that you might give in defining the public interest, in setting the standards, in providing what some people call the guardrails?
Well, I think what made the early history of this and the early history now of the EU regulatory regimes is that they developed on their own based upon complaints that were made from the public and then investigations of the complaints and then acting on it. So in other words, we're not talking about in the best possible situation. In the European sense, they talk about freedom of expression, and which is in their legal world. They don't have a particular First Amendment, and maintaining freedom of expression. And it's a very difficult thing to come to a dogmatic definition. So it's a changing definition, as it was, and by the way, the creation of the regulatory regime here in the US, it changed depending upon what happened with the technology. Example, Orson Welles, a famous actor and director, did a radio broadcast. He had a regular radio broadcast, and it really was a reenactment of the War of the Worlds. And supposedly a Martian spaceship lands in New Jersey. Well, didn't have a regular announcement. This is a reenactment. And so on. So the panic happened in New Jersey. So an FCC regulation came out afterwards that said you have to label reenactments as such and make it clear that the audience knows. That's not something you can write in beforehand using a new technology. You have to experience the technology. It's basic as that. It's a world where the regulations will change depending upon what's actually going on. If there's a national emergency about an epidemic, you can't get on a infinite reach communication system and make up stories about drugs that might kill you to take, just to take, for the audience to take. In fact, there were fatalities in that. So that would have resulted in a regulation about responsibility for recommending prescriptions to the general public. Actually, that was established already through the Brinkley case in 1931, where he was saying, let me put goat glands in your testes and you'll be more potent. And he had a huge audience and he was making money. So in Section 230, people argue about, yes, there has to be some immunity to making recommendations. But by the way, Wikipedia uses Section 230, but they tell me that they're a nonprofit. They have to use Section 230, otherwise they wouldn't be able to operate. They're not trying to make money. So what happens? We don't have a regulation in place, for example, that says that you have more responsibility for what you recommend or what you broadcast or what you issue over the internet. You don't have any other responsibility other than libel. So therefore, you see eventually libel suits. But libel suits take a long time. The First Amendment has certain requirements for it. Obviously, Murdoch didn't settle in that case if he thought he was going to win, right? Or his insurance companies. So they settled, but it doesn't stop the same behavior happening over and over and over again. So I think you have to accept the idea that initially there's going to be a period of creating the regulations, enforcing the regulations, and arguing through what is allowed and what isn't. I mean, the national security of the United States is in danger. And that was recognized early on by the Radio Commission and then later by the FCC, because when you know, all the stuff about Russian interference in the 2016 election, really, the Russians didn't violate any laws doing that on the internet. Disinformation, bad information, they weren't violating it. That's why they never nobody got indicted for that. Even the case involving the one case that they did make, the Justice Department and filed, that they had to dismiss it because they really weren't doing anything anybody else could do on the internet. That's how ridiculous it's become. And yet I don't hear the chorus coming from anywhere in let's say, the pro-national security area about this. So I think I'm not sure where we go. I mean, I think the problem really is that there's some fundamental changes that need to happen, and we haven't had a big enough crisis yet, apparently, to warrant change.
Lowell, I'm just kind of curious about where your colleagues are now. You mentioned that long ago when you first started teaching at Berkeley, there was a kind of reflexive opposition to regulation, or more a focus on standards and practices. What about now? Are journalists starting to rethink that question?
Well, I mean, Nick Lemon has a piece in the Columbia Journalism Review today talking about licensing journalists, so you know who actually is a journalist and who isn't, and has some standards to it. I think that's more difficult and raises more questions than, for example, having general standards on what you call news and don't call news, right? I mean, I think we're going to have to be a little more subtle than that, because if you had to be licensed to be a journalist, then I would never have gotten a start, right? I mean, you couldn't get a job in when was that? 1970. Newspapers had guilds, and the guilds had power, and that was where, and by the way, we had terrible newspapers in the Bay Area, I think, and primarily in Los Angeles, except sometimes the LA Times, in California. I mean, maybe the McClatchy newspapers were up and down, but they generally were heads above everybody else most of the time. And so you need independence to a great extent in journalism. I think licensing gets to be a different kind of issue and raises questions that I don't think we can really answer. But we need to recognize the crisis that's going on. People don't know
and your colleague in that case is at least responding to the same crisis that you're concerned with. Nick Lemon.
Well, he's responding. You're going to see more and more action. The Justice Department is engaged, apparently, in more antitrust suits than in the whole history of the Federal Trade Commission and the Justice Department since the muckrakers inspired people to put that law into effect and so on back, 110 years ago. There are now more cases pending. There apparently were no major cases since the Microsoft case in 1999 on antitrust. That was because of a consensus that developed during the Clinton administration, where they joined in the deregulation ideology that Reagan introduced. So they did the same thing to the banking industry and so on and so on. We know every time we do this, we wind up with this giant collapse or crisis without moderating how far we go into deregulation, and then having to come up with a alternative in a crisis that's unprecedented.
Lowell,
Susan, any other thoughts coming in from
well,
our audience?
again, it's trying to uh, summarize some of the longer points of view. But I wonder if I think there's sort of two questions emerging from this synthesis. The first is my query. Have you and Erwin Chemerinsky been in conversation about the First Amendment? You referred to him a couple of times.
I did a Zoom event with him a couple of years ago, and
You did.
he was opposite actually Newton Minow's one of Newton Minow's daughters, who was the president of Harvard Law, Mary Minow, and about the issues of who decides what, that this is good or this is bad and so on. Hey, I say editors decide all the time,
Mhm.
but editors also have in their mind certain guidelines about how they operate. And those guidelines, to a certain extent, should be out there publicly. And if you want certain privileges, in the past, before 1987, the privilege of broadcasting over the air was defined by the government. Who got to do it and what the consequences were. There's no such standard currently in either broadcasting or print.
Mhm.
Remember Leslie Moonves' statement in January of 1986 in the wake of Donald Trump's performance in the Republican debates. He said, "Keep it up, Donald. It may not be good for America, but it's good for CBS."
Mhm.
He said it the opposite way, but that was essentially it. They made a lot more money in advertising, in ratings, because of Donald Trump. Instead of losing money on political debates, which get to be boring often or people don't tune into, he livened up the debate. We all know that sex, death, and violence sells.
Mhm.
And you could just run that all the time with a little pornography on the side. But and you'd have the biggest audience. And that's what's happened.
Mhm. Yeah, with an economy dominated by the market.
And look at the fortunes that were made by Silicon Valley without regulation. How fast that happened and exists today. And those are questions also that have been raised. But you don't see any, for example, you don't see anything in the streaming world on any of the platforms that deals with, for example, the economic model of the companies or their own economic model. How do they choose which film they're using? What
Mhm.
algorithm are they using? We don't know.
Well, Lowell, it's certainly wonderful to have this hour with you. And Peter, thank you for your questions and for getting to a fairly expansive topic that you call a crisis. And that I think, Lowell, you will continue to sort of provide more and more information that will help I think build what needs to be a kind of movement of interest and attention on these topics. Do you see any, you mentioned Governor Newsom, do you see any congressional leadership, any nonprofit organizations? I know at the beginning of the internet, there was the sort of electronic frontier, but mostly that was pushing for that infinite reach. And
I had some discussions over the years with people like the Electronic Frontier Foundation, all of whom were in favor of this open First Amendment.
right,
Father, don't touch it. It's wonderful. Everything's going to be great. It's going to be utopia. And
right,
then they figured out how to make money. And it's changed since then.
right.
And I would say that even I know people I've talked to at Google, for instance, have said on the record that the European regulations are at least thoughtful.
Mm-hmm.
And it is because I was somewhat that I would look for more guidance there than anywhere else at the moment. Not that they haven't made mistakes, et cetera, but it seems to have been more thought put into it as a reality that has to be changed and that they're willing to change.
Mm-hmm. Right, very definitely. I know that public broadcasters in Europe have done a good job around educating people about what's at stake and what's emerging from Brussels. So I think there's a lot of roles for each of us to play. I think this also suggests a really important OLLI course to spend more time with this, as well as the other issues around AI. Again, another, technological innovation with no guardrails, no standards.
It has to be, there's a panic that's been created about AI,
Right.
right? And nothing has been done to ameliorate that pattern, that panic, right? They say it's an existential threat. What do you mean? How?
Yeah.
And should we stop it from happening, right? But instead, it's become really a struggle over who is going to profit from it.
Right. Right. Well, thank you for the education you've provided us today. I want to mention to folks that we will meet again same time next Friday, 10:30 to 11:30. We'll bringing together John Haveman, the economist, with politics professor Howard Schweiber. And the two of them will talk about the two economic plans within at the National Front. What's at stake. We will then also the following week, same time, same place, Dr. Diane Ehrensaft will talk about the gender revolution and the controversies surrounding gender. So please return. These are all speaker series that are open to the public, but we very much would love to have you join the OLLI membership. And so take a look at the website and join us. And Peter, Lowell, thank you very much for today.
Yeah.
Thank you.